Ladies and gentlemen, Assalamu alaikum. Before coming to the topic assigned to me, I would like to say that in AJK, yet we have no legislation, proper legislation about ADR system. A bill was moved to the legislative body in April 2022, which is yet pending finalized. Thus, for academic purpose, I would like to say something about the topic. Before dilating upon the assigned topic, that is building trust in domestic arbitration, cultivating confidence in ADR mechanisms, I would like to facilitate the erudite organizers of Pakistan International Disputes Weekend, particularly Barrister Mia Shiraz Javed, who is calling the shots of this august event and has left no stone unturned to successfully orchestrate the event for which he deserves appreciation. Ladies and gentlemen, arbitration is a widely used method for resolving disputes, offering parties an alternative to litigation in the courts. One of the key advantages of the arbitration is the finality of awards, which is essential for fostering trust in the process. However, for arbitration to be effective, the recognition and enforcement of arbitral awards are crucial. In Pakistan, like in many other jurisdictions, the recognition and enforcement of arbitration awards has been a subject of legal development and debate. This analysis explores the legal framework and political challenges associated with recognizing the enforcing arbitration awards in Pakistan. At the outset, I would like to shed some light on its legal framework. The recognition and enforcement of arbitration awards in Pakistan are primarily governed by Arbitration Act 2011 and the New York Convention on the Recognition and Enforcement of Foreign Arbitral Award 1958, New York Convention. Pakistan became a party to the New York Convention in 2005, which marked a significant step towards harmonizing its arbitration laws with international standards. Ladies and gentlemen, the Act provides a comprehensive framework for recognizing and enforcing foreign arbitral awards in Pakistan. Section 7 of the Act stipulates that a foreign arbitral award, whether commercial or not, shall be recognized as binding and enforced upon application in writing to the High Court. This alignment with international norms is a positive development for arbitration in Pakistan, as it allows foreign awards to be enforced relatively easily. However, regarding domestic arbitral awards, the legal framework must be clearer and pose significant challenges. The Pakistan Arbitration Act 1940, which governs domestic arbitration, needs to be updated and adequately address the recognition and enforcement of awards. This creates inconsistencies and confusion in practice, as parties often resort to civil courts to enforce domestic awards, leading to lengthy and costly litigation. Now coming to the challenges in practice, while the legal framework for the recognition and enforcement of foreign awards in relatively robust, the practical challenges in Pakistan are substantial. Number one, inadequate legal infrastructure. Pakistan's judicial system faces significant backlogs and delays. Take the example of AJK, from where I belong to. Till 31st December 2023, AJK High Court had 16,139 cases pending adjudication due to one or the other extraneous reasons. In this backdrop, reliance on ADR mechanism for speedy dispute resolution has become the need of the hour. Number two, lack of specialized arbitration courts. Unlike some jurisdictions that have dedicated commercial courts for arbitration matters, Pakistan lacks specialized courts for arbitration. This leads to judges with limited expertise handling arbitration-related issues, potentially affecting the quality and consistency of decisions. Number three, judicial interventions. There have been instances of excessive judicial intervention in arbitration proceedings in Pakistan, with courts frequently interfering with arbitrator decisions. This not only contradicts the principles of arbitration, but also discourages parties from choosing arbitration as a dispute resolution method. Number three, enforcement of domestic awards. As mentioned earlier, the legal framework for enforcing domestic arbitral awards is unclear and outdated. The absence of a clear mechanism and a specialized court for domestic arbitration cases hinders the effective enforcement of awards. Number five, challenges faced by foreign parties. Foreign parties often encounter difficulties in navigating the Pakistani legal system, including language barriers and unfamiliarity with local procedures, which can further delay enforcement. Number six, public policy exception. Like many jurisdictions, Pakistan recognizes the public policy exception to enforcement under the New York Convention. However, applying this exception can be subjective and open to abuse, as it allows local courts to set aside awards on vague grounds of public policy. To improve the recognition and enforcement of arbitration awards in Pakistan, several reforms initiatives are needed, which is overhauling domestic arbitration laws, capacity building, alternative dispute resolution promotion, and improvement of courts infrastructure, streamlining procedures. Before parting with my discussion, I would like to conclude that building trust is neither a one-time act nor a linear process. It requires consistent effort, understanding, and most importantly, the unwavering commitment to fairness and justice. Over the years, I have realized that while laws and treaties might change, the human need for trust remains constant, and in the ever-evolving domain of international arbitration, it is this trust that can make the differences between dispute and resolution, between skepticism and faith. Thank you very much for patient hearing.